Guys, we have ourselves two updates on the Ripple v. SEC lawsuit. Ripple just came out with a document, and the SEC also just came out with a document. So what the SEC basically has done just now is file this. The SEC has filed a letter of supplemental authority in further support of its motion to strike the fairness defense. Ripple, a couple of hours later, I believe 4 hours later, has already responded, and oh boy, does this get interesting. All right, dear judge, plaintiff SEC respectfully submits this notion or notice of supplemental authority in further support of the motion to strike the fourth affirmative defense, in which Ripple asserts that it lacked fair notice, that its conduct was in violation of law in contravention of Ripple's due process rights. On January 21st, 2022, a Southern District of Florida court issued the attached opinion granting the SEC's motion for summary judgment in the SEC v. Keener, and the court concluded that the defendants unlawfully failed to register as a securities dealer as required by the SEC. In doing so, Keener rejected the same fair notice argument Ripple asserts in this case, and that the SEC has moved to strike, holding that defense fails as a matter of law. Like Ripple's arguments regarding the application of the term investment contract to its offers and sales of XRP, the Keener defendant contended that he had no fair notice that his conduct would be unlawful because he lacked notice his conduct could make him a dealer as defined in the Exchange Act. Now, the Keener defendant argued the statutory language of Exchange Act is not transparent, which is why the SEC had issued so many interpretations over the past years. And two, the SEC position in this litigation directly contradicts its prior guidance, which defendants reasonably relied upon in determining that he is not a dealer. And three, whether the defendant had fair notice on a new way in which the exchange definition of dealer would be applied is a factual question that must be decided by the jury. Now, in rejecting the fair notice defense as a matter of law and awarding the SEC summary judgment, Keener held that the defendant had noticed that his conduct could be unlawful based upon the express language of the Exchange Act, decisions from this circuit applying to the definition of the dealer, and the SEC guidance itself. Keener further held, to the extent defendants contend that the SEC was required to set forth guidance specifically on the investment products at issue, the court is unaware of and defendants has failed to cite to any authority requiring the SEC to issue precise guidance on the regulations it enforces. And that's actually the key part of this entire document here. The court is unaware of, this is again what the SEC is claiming, and defendants have failed to cite to any authority requiring the SEC to issue precise guidance on the regulations it enforces. So in my own head, this actually makes absolutely no sense, because if you're going to enforce some regulations, I think it's like mandatory in a logical sense that you have precise guidance. Just makes sense to me. But according, Keener provides additional authority for striking Ripple's fourth affirmative defense, which I can't really see the two how they relate too much in a certain sense, but Ripple obviously responded rather quickly, and then we'll do some interpretation from what lawyers are thinking about this. Let's just quickly read both these documents and then go into what it means. We write on behalf of Ripple to respond to the SEC's letter, notifying the court yet another out-of-circuit decision in the SEC v. Keener. As in its previous letter, the SEC once again ignores the differences in procedural posture. Its latest case was decided on a motion for summary judgment, and upon review of the record, Keener at point 14, whereas its motion, or I guess asterisk 14, whereas its motion to strike asked the court to dispose of Ripple's defense without even considering the factual record. The SEC also continues to ignore that in this circuit, even disputed or substantial issues of law are more properly determinable only after discovery and a hearing on the merits. And let's see here, vacated on the ground. The SEC has not identified any controlling authority granting a motion to strike a defense comparable to the one Ripple has asserted here. And with such controlling authority, the SEC's motion must fail under the Second Circuit standards for motion to strike. No amount of out-of-circuit cases in different procedural stages will change that. So what it refers to, guys, is that right now the SEC versus Ripple case and the SEC v. Keener case are in two different stages, right? And so whatever happened to the Keener case, Ripple's arguing, is not really relevant in any way, shape, or form. Now, let's quickly see, because I saw a couple of guys had some comments on this, but you don't really see this, but I have over, I think, 40 different tweets open here over on the top of just different things to talk about, as I'm going to definitely have to make a couple of different videos, I guess, because I just have so much stuff. So let's quickly actually check this out. I believe Jeremy Hogan had a very interesting opinion on the matter. Let's quickly go ahead and bring this one up if the internet would allow it. Here, let's quickly check out Jeremy Hogan. All right, so what Jeremy Hogan had to say about this entire case was, when me and Attorney Kellogg see the exact same thing, he just says it much better. You know it's got to be right. And before that, let's quickly see. This is before the document came out. The SEC is not winning these cases at the motion to strike stage, which is what they're kind of alleging, where the Ripple case is at. Because again, right now, the decision that they're waiting for in this lawsuit is the motion to strike. And in that sense, they're already over it. But later in the litigation, at motions for summary judgment, the F&D depends on the specific facts of each case and will be decided at summary judgment and not at an MST, in my opinion. Oh, so, sorry, that should be MTS, as in motion to strike. I'm tired today. This case from the SEC might help them later on, but it doesn't help them right now. Once more, what that refers to, guys, is that the SEC just came out with a document which is potentially relevant, but really in no way, shape, or form relevant for us in the situation right now. So to me, it also doesn't make any sense why they would bring it up right now, why they would maybe because it's document 420, they wanted to claim it. So they were like, you know what, let's go for it first, and then let's not have Ripple have it or something like that, because it makes absolutely no sense. So is this a really big deal? No, but it's an update on the Ripple v. SEC lawsuit. All right, one thing I quickly want to say actually is that when you check Henry here, he asked, is it normal that they replied so fast? Is the ruling coming soon and they know it, or they knew what SEC will submit today? Is it me, or is it a little strange about this lightning fast response? Because again, Ripple responded ridiculously quickly actually, which was kind of scary from a certain perspective. Now, what John Deaton had to say was, it didn't take, because the case cited by the SEC is slightly above meaningless at this point. If anything, it shows how scared or sacred the SEC is on the fair notice defense. If it was a decision from the Second Circuit, it would be a big deal. It's like comparing apples to oranges, pun intended. So once more, guys, it is relevant, but as of this point, it's not relevant. It might get there eventually, but as of this point, guys, you already know, it's just at a different point in the lawsuit that these guys are comparing it to. So it just doesn't make a lot of sense to say, hey, something happened in this lawsuit, so maybe it's relevant to Ripple's. No, it's not, because you're at a different point. You're at a different argument. It's about a fair notice, okay, but at a different point in the lawsuit, it makes absolutely no sense to compare these two things with each other. And guys, what I'm basically making right now is a very big crypto update, because there's so much stuff which happened right now regarding Biden, crypto regulations and everything. But I'm also making for you guys a new overview of the Ripple v. SEC lawsuit. I have it open somewhere as well. But I just want to go over everything that's happening right now and everything that you need to know about. And if you guys get this video to, I'm going to say 1,250 likes, I'm going to ask Jeremy Hogan again for another interview, and we might be able to get some more additional facts and information. So if you guys smash that like button, we're going to do another Jeremy Hogan interview, hopefully. That could be very exciting. Make sure you press the like button, guys. Make sure you press the like button. And that was it for today's little video. See you guys again in another one.